and the team. Our members and
recording in
GM
progress
and all present on the platform come to this meeting. Just in terms of the presence of members, we have Honorable Mikalakis, Honorable Maleka, Honorable Mutsamai, Honorable Amini, Honorable Dag. Haven't missed any other members. From your side, Gershwin, do we have any apology, honorable member?
Good morning, Chairperson. If you don't mind, my video is off due to the network.
No, it's fine. It's fine.
The minister has apologized, Chairperson.
Okay. DM is present. Okay. No. Thank you very much. Hope I haven't missed any other honorable member, but I know the member join us as once again, good morning and welcome. I think today we continue with our deliberations on the protection of constitutional democracy against terrorism and related activities amendment bill. Honourable members referred to the committee on 9th of November 2022. The protection of constitutional democracy against terrorists and related activities amendment bill is intended to date the protection of constitutional democracy against terrorists and related activities 2004. The act in order to attend law to give effect to certain constitutional court judgments and his experience with investigations and prosecutions. On members, we had our first meeting with the Deputy Minister of Police on the 30th of November 2020, where we were briefed by the department on the bill. Members will also recall that the Deputy Minister indicated the need bill to be dealt with as expeditiously as possible, and for the NCOP bill this year and South Africa from being grey-listed by the Financial Action Task Force. This was also stipulated in a letter of urgency by the Minister of Police. Some amendments of the provisions in POC-DTARA Act relate to financial sanctions and the criminalizing of terror financing, which were part of the recommendations made by the FATF. And then just in terms of the process that has been undertaken by the committee, the B version of the bill was advertised for public comment on social media platforms from the 30th of November to the 6th of December. In addition, the committee contacted organizations who had made submissions to the Portfolio Committee on Police to ascertain whether or not they had further submission. Just in terms of what we have on this, in terms of from organizations and individuals, following applies. We receive submissions from of religion in South Africa for the Sussexism and Extremism Research, the International Committee of the Red Cross, an individual by the name Notorious, and the Independent Party. And I think copies of these things, as well as the summary there, have been provided. However, given the short timeline for this bill, we opened the process for oral submissions. Organizations and individuals were also requested to inform the committee oral presentations. With this in mind, that today we are representations from the following organizations who requested to be afforded this opportunity. We'll receive the presentation from FOSA, Cape Independent Party, and from Dr. Ace Kuman from Stern. In terms of there are two other missions, GEO South Africa, as well as AfriForum, that have stated interest in terms of the process. I think just could not make it today, so we'll. But I have indicated that they're available tomorrow at 12. So in tomorrow's meeting, we'll actually allow GEO South Africa and AfriForum, if they're available, to make their oral questions. Just in terms of the process today, honourable members, like I said, we'll receive the 3 oral submissions. Thereafter, individually, the department will respond to individual submissions made after each presentation, and thereafter, committee members will be given an opportunity if they have issues of clarity, etc., based on the oral submission as well as the department's response. Okay, sorry, I've not been looking at the Honorable Mikalakis. I see your hand has been raised. Is my signal not too good?
No, Chairperson. I have just a question on procedure, if I may, please.
Okay. Before that, Honorable Mikalakis, I just got a message that I'm breaking up a bit. Is that the case?
Well, Chairperson, my signal is also bad. I'm not sure whether it's you or me, so I can't really advise you on that.
Yeah, I think, Chair, if you can close your video, it will be a bit, I think.
Okay. All right. I don't know what you missed out on, but in essence, honorable members, I think just in terms of today's proceedings, we will be receiving oral submissions at least by 3 organizations. And just in terms of that process, we'll allow the organization to present. Thereafter, the department will respond. And we'll allow also honorable members, if they have questions of clarity, to raise those as well. That's just the gist of today's proceedings. And yeah, then Honorable Mikalakis, you've raised, please raise your point.
Thank you very much, Chairperson. Please tell me if my signal is bad. Chairperson, we have been given a deadline, which at the last meeting I indicated that I'm uncomfortable with, since it followed on the electoral bill, where we also put under quite a lot of pressure. That set aside, my question relates to this in the sense that if we make amendments to this bill, it will have to go back to the National Assembly. And I am not at this stage 100% satisfied, and I would like the department's response on this, please. I'm not 100% satisfied that the department is not just going to reject the inputs of the public simply because they don't want to make amendments, because there is not enough time to send this back to the National Assembly to consider our amendments, because then the whole public participation process would be a farce. And I do think that those who give input today also need to be put at ease, that the department would seriously consider their inputs, and if the committee makes recommendations for any amendments to this current version, that there will be enough time for the National Assembly to consider it. Because if there's not enough time for the National Assembly to consider it, then this is just a tick box exercise, which I think you and I would agree is not something that we wish to do in this committee. So I would just like some form of a response from the department, indicating to us that there is enough time, if we make any amendments, for the National Assembly to still consider those amendments, please. Thank you very much, Chair.
Thank you very much, Honorable Mikalakis. I just want to remind you that this is also our process. And I think it's important, we'll allow the department as well to make that commitment, that it's important for the department to consider all inputs that we receive. But more importantly, it's important for us as members of the committee to consider and deliberate on what is being presented to us. And if we feel that there are issues that need further deliberation on, etc., I think it's really up to us as a committee. It's Parliament that actually makes the laws at the
Absolutely.
end of the day.
Thank you, Chair.
So yeah, perhaps. And I think it's also our consideration that the department responds accordingly to everything that is being submitted to us as a committee. But thank you very much, Honourable Mikolakis, for that input. Whoops, sorry, I muted myself. Okay, we have Honourable Dango. Is it on the same issue, Honourable Dango?
Yes, on the same issue, Chairperson. Chairperson, I think we need to also consider when we taking these things into account that there's a timeline on these particular matters, and that grey listing could be very real from foreign powers who actually are seeking to grey list this particular country for other reasons. Thank you.
Okay, no, thank you very much, Honourable Dango. I think we also dealt with that matter last week as well. But I think according to the sentiments raised, I think it's just important to indicate to civil society as well as South African citizens at large that we do consider their inputs. We obviously apply our minds. I think the only problem is when we kind of have to continuously engage in a process, and there are other programs of the NCOP that sometimes clashes with our work. But be that as it may, I think it's important to send that message across that we do apply our minds and consider inputs, and we take it very seriously what the public says and the comments that they make into any process that we run. But thank you very much, honourable members. I think I'll obviously need also guidance from yourself, Gershwin, to some extent. We did provide times to organizations for them to make the necessary inputs. And I think before that, I see Honourable Deputy Minister, you probably have something to say as well. Okay, Honourable Minister, DM, let me hand over to you first, and then we'll then move into the actual the oral submissions. Deputy Minister.
No, thank you very much, Chair. I just want to assure members, even though it's not necessary for me to do that, because this is your process, is the NCOP process. Ours is to clarify things that needs to be clarified, and there will be open and fair engagement from our side as we respond to questions that are raised. And equally, I believe there will be an honest and a fair engagement, both from the public and from the committee members. If a proposal is made and we respond in a manner that suggests that proposal will not be necessary for the purposes of the bill, it won't be because we want you to rubber stamp the NEA processes. We don't want to do that. The committee must engage in its process. The public must participate. We are going to take them into considerations, their input, and will honestly and genuinely respond to their input without suppressing anything. So I want to ensure members of the public and the honorable members of the NCOP that we will not say no to a submission for the sake of ensuring that there are no amendments. If you will arrive at a conclusion that a particular section must be amended to read differently, you will pass the bill and it will go there for the, if the NA must convene to process that, that will have to happen. But we are not here to make you rubber stamp any process, but we are sincere and honest. Like we said to you when we appeared, that we will be available to work with the committee throughout until the process is concluded. Then we're doing exactly that with no bad intentions. Thank you very much.
Thank you very much, DM. Our members, just in terms of the program that you received, so the first presentation we're expecting is from FOSA. Thereafter, we'll expect a presentation from the Cape Independent Party, and thereafter from Stern by Dr. A. Skuman. We'll try as much as well to manage the time. I think if on members, if you looked at the submissions that came through, I think they're quite clear and they're also very specific. We'll try and manage the time. If we have time in between, we'll actually just break for tea, I guess. But yeah, we're going to then run with this process. I think, if I'm not mistaken, and I think we have Gershwin, I'm not sure who will make the presentation from FOSA, but I do see on the platform we have, sure, I've lost it again. We have Daniela Alabak, if I'm not mistaken. Yeah, I hope I pronounce your name correctly as well. But if I can maybe then hand over to FOSA, ma'am, over to you.
Wonderful. Good morning, Honourable Chairperson and all the committee members. Honourable Chairperson Sheikh, you did pronounce my name correctly. I'm very impressed. Thank you very much for this opportunity to present to the committee on the Pocatara Amendment Bill. From 4SA side, we trust that our submission will be brief and that it will give the committee a unique perspective that will assist it in drafting a law that practically benefits our nation. I'm Daniela Ellerbeck, I'm an attorney, and I am the legal advisor to Freedom of Religion South Africa, or 4SA. So turning to, let me just get my screen share right here, the bill. And to introduce 4SA, 4SA is a legal advocacy organization, and we work to protect and promote the constitutional right to freedom of conscience, religion, thought, belief, and opinion, commonly referred to as the right to religious freedom, which is found in Section 15 of our Bill of Rights in the Constitution. And we currently have an endorsement base of religious leaders representing millions of people in South Africa. Our constituency spans various denominations, churches, and faith groups. So, for example, during lockdown, 4SA was mandated by religious leaders and organizations representing at any point between 11 and 18.5 million people, including 10 million people from the African Indigenous and Spirituality churches, from a cross-spectrum of churches, denominations, and faith groups, to engage with government and to make submissions on their behalf. So that is who 4SA is. Then just briefly to explain the ambit of the right to religious freedom, the Section 15 right I've just mentioned, before we turn to the bill specifically. Section 15 protects the right to religious freedom, and that includes your right to freedom of conscience, religion, thought, belief, and opinion. So we see that it is a very wide right. And we also see that because of Section 82 of the Constitution, this right applies not only to individuals, but also to juristic persons, such as faith-based organizations, and that it overlaps to quite an extent with other fundamental rights, such as the right to freedom of association, freedom of expression, and so forth. Because freedom of religion entails being able to tell others about your faith, such as, for example, our Constitutional Court's definition of religious freedom, which is, I quote, the right to entertain such beliefs as the person chooses, the right to declare religious beliefs openly and without fear of hindrance or reprisal, and the right to manifest religious belief by worship, practice, or by teaching and dissemination. Freedom of religion in this case implies an absence of coercion or constraint and may be impaired by measures that force people to act or refrain from acting in a manner contrary to their religious beliefs, end quote. In other words, to put it simply, religious freedom is the right to believe what you want to believe and then to freely live out that belief by words and actions in the public realm and to associate with others who believe the same. As a human right, it attaches to you as a human being and you take it wherever you go. So for example, you don't leave your right to dignity, your right to religious freedom, your right to freedom of expression behind you when you close your front door in the morning. It attaches to you as a human and you take it with you where you go. And all of these rights that are found in the Constitution's Bill of Rights, our Constitution says can only be limited by a law of general application if that law passes the Constitution Section 36 test. So turning to the bill at hand, while 4SA respects the need to bring the amendment bill to the Product Torah Act to align us with international law, we are concerned that it may have unintended consequences on various constitutional rights, which we've just said can only be limited by a law if that law passes the Section 36 test. Now, given 4SA's mandate, which focuses on religious freedom, obviously our input will only focus on the proposed amendments and to definitions that unjustifiably impact on the right to religious freedom, freedom of expression, and freedom of association. So Section 15, 16, and 18 of the Bill of Rights. Now, specifically, the one concern that remains for us with this bill in the version that it is currently, the B version in front of the Select Committee, is the wide definition of terrorist activity. Because again, we're dealing with a law, the Principal Act and this bill, which criminalizes terrorist activity. So it all boils down to what is terrorist activity. And we are concerned because currently the definition runs over 2 A4 pages. I'm looking at the definition printed out here. It is actually, I would say 2¼ pages, A4 pages. So we see in it that it is quite a long definition. And it contains various broad phrases that are open to abuse. I've just taken 3 phrases out of that definition as examples. And so, for example, you'll see that the broad definitions and undefined phrases include to overthrow the government, serious public emergency, and then the circular definition contained there, which is intended, or by its nature and context, can be reasonably regarded as being intended in whole and part, directly or indirectly, further the objectives of the entity engaged in terrorist activity. So what terrorist activity is defined as is obviously crucial. And the fact that there are broad phrases that are open to abuse are concerning. And 4SA points that out in our written submission to this committee, because, for example, during lockdown, and even when we had post-lockdown, when we had the health regulations in place, we had certain members in the executive arm of the government label certain civil society organizations engaged in enabling public comments, specifically on the Department of Health's proposed health regulations as quote unquote instigating terrorism and or quote unquote sabotage. So that is concerning when one sits with broad and vague phrases in terrorist activity, because these are open to abuse by, when one drafts a law, you want to draft it as tightly as possible. So it's never open to abuse by, a future government. So this is problematic, that terrorist activity means these 3 things because these are vague. So for example, there's no specified criteria for what is a serious public emergency. So there's no definition and there's no criteria. So it says, it doesn't say what this thing is, and it doesn't say, 1, 2, and 3 need to be made for this thing to be happening. Similarly, all of these are open to abuse. And this is concerning because terrorist activity is a crime that has a penalty of life imprisonment. And the expanded definition needs to be read with Section 3 of the Principal Act, which makes it a criminal offense to, amongst other things, assist an organization deemed to be engaged in terrorist activity by, providing skills or expertise, or to solicit support for, that organization. So it is, and I mean, that carries a penalty of 15 years. So again, we need to look at this definition of terrorist activity to make sure that it isn't open to abuse, because already we've seen civil society organizations enabling public participation in what is a public participatory, open and transparent democracy being labeled as being engaged in sabotage and and instigating terrorism, which is obviously not something we want. So the Principal Act, I also want to point out, criminalizes any involvement with or funding of an organization. So this is concerning to the religious community, given that the religious community is often at the forefront of criticizing government and or facilitating public participations, be that in elections or the legislative process or any numerous number of other civil society activities. And so in light of this, in light of if you go to jail for 15 years, if you fund an organization that can be deemed to be involved in terrorist activity, and terrorist activity has this long definition running over 2 A4 pages with vague, undefined phrases that have no criteria to them, that are open to abuse, that is concerning. So with this definition in the bill, we see that it could potentially unintentionally used to drastically limit the right to religious freedom, which protects the right to hold opinions and beliefs and to live these out publicly and share them. Freedom of expression, which again protects all expression apart from propaganda for war, incitement of imminent violence, and the advocacy of hatred based on race, ethnicity, gender, or religion, and that constitutes the incitement to cause harm. And freedom of association, which protects the right to freely associate with those that one chooses to associate with. So what 4SA recommends is that we narrow down the definition of what is seen as terrorist activity to avoid abuse by a future government. For those who are interested in reading on the legal framework, I can refer you to page 4 of 4SA's written submission, where we do an overview of the international as well as the domestic legal framework, looking specifically at religious freedom, freedom of expression, and association. And our recommendations are very small. We would say that the definition of terrorist activity must be narrowed by excluding creates a serious public emergency or a general insurrection within the Republic. And alternatively, that criteria needs to be set down for what constitutes a serious public emergency or a general insurrection. Thank you very much.
Okay, thank you very much. Are you done, Ms. Alabek? You just went quiet.
Yes, I am done. We trust that the submission would be helpful, and I would gladly answer any questions that the committee or the department has.
Okay, no, it's fine. Thank you very much for your submission and your presentation. I think what we'll do is allow the department to respond to the submission. Thereafter, if you have anything you'd like to add, we'll allow you to do that. And then members would, if they have any questions for clarity, they would then raise that. Over to the department. Deputy Minister, am I working through you on this one, or am I working through the legal team?
I think you can work through the legal team. It will be quicker and easy. Advocate Bell and Advocate are here to assist.
Okay, so we're handing over to Advocate who? I didn't hear the name.
Ask Advocate Bell. She will indicate who will in the team assist her.
All right, cool. Okay, Advocate Bell.
Good morning, Chair. Good morning, Deputy Minister. Good morning, honourable members on the platform and other colleagues. I'm here with our Acting Secretary, Mr. Ramaru, and Advocate Kritzinger, and Mr. Lisani that's helping us with the presentation. And we're going to ask Advocate Kritzinger to take us through the presentation. We also have other members from various departments, Chair, that are on the platform that will assist us with responding to questions that we are unable to answer. We've got Brigadier van der Walt from the SAPS Legal. We have Mr. Peter Smith from Financial Intelligence, and we've got Advocate Sean van Breda from the Office of the Chief State Law Advisor that will also assist us. Thank you, Chair.
Advocate
Good morning,
Kutsela, you
Honourable
can
Chairperson, Honourable Deputy Minister, members of the committee, and also Acting Secretary for Police Service and other members on the platform. I would just like first to thank the committee for giving us the opportunity to respond to the submissions by Freedom of Religion South Africa. We have analyzed the written submissions, and we have made a summary of the comments, after which we will provide our response. I would like to indicate that as the public submissions came in yesterday, we started with preparation of the comments, and we prepared a collective submission and presentation responding to all the relevant submissions. But later, when we received the agenda for today's meeting, we realized that it's not in sequence with the agenda. So I will be asking the person that's flighting the presentation for us just to take us through the relevant slides that we are dealing with at a particular moment. Okay, first of all, if we go to slide 3, there is an indication of our summary of the comments by Freedom of Religion of South Africa. In terms of the comments, the commentator has, as we heard from the verbal presentation also, indicated that the definition of terrorist activity in clause 1 contains various broad phrases that are open to abuse. And it was indicated that it's problematic that terrorist activity, amongst others, means any act committed in or outside the Republic which creates a serious public emergency situation or a general insurrection in the Republic, and which is intended, or by its nature and context, can reasonably be regarded as being intended to directly or indirectly further the objectives of an entity engaged in terrorist activity. The commentator has indicated that this provision is vague and it's open to abuse. And the opinion is held that the actions of civil society organizations that, for example, facilitate public awareness into the legislative processes may be seen as terrorist activities. Next slide, please. It is also indicated that the unintended consequences is to criminalize voices of those opposing government, and it could limit the rights of religious freedom, freedom of expression, as well as the freedom of association. As the commentator had indicated, it is recommended that the definition of terrorist activity be narrowed down to exclude an act that creates a serious public emergency situation or a general insurrection in the Republic. Next slide, please. In response to this comments, I would first like to just stand still at the definition of terrorist activity. It's very important to take note of the fact that the definition of terrorist activity rests on 2 legs. The first part of the definition refers to any activity that can cause harm, plus it must achieve the intended objectives mentioned in the Principal Act. And those 2 elements together equals a terrorist activity. The definition seeks to explain that there needs to be a clear link between the activity that can cause harm and the intention of that activity to achieve the objectives in the Act. If activities lack the necessary terrorist intent, which is usually aimed at terrorizing the civil population or government, it cannot be considered as a terrorism act under the Principal Act. If one element of the crime is missing, the crime is not established. The circumstances and evidence of each particular case will have to be looked at to arrive at a conclusion, and prosecution under Poctatara is only possible with the written authority of the National Director of Public Prosecutions, where this safeguard is built in. Next slide, please. The examples mentioned by the commentator that the actions of civil society organizations that facilitate public awareness into the legislative processes will therefore not fall within the ambit of the definition of terrorist activity because it lacks the intent to cause any harm. The comments regarding acts that create serious public emergency situations or a general insurrection in the Republic are however noted, apologies, but yet again, these acts will have to be tested against the definition of terrorist activities before any prosecution can be instituted. So one always has to refer back to those two key elements of the terrorist activity when determining whether an act is indeed a terrorist activity or not. There is no intention to criminalize voices of those opposing government processes. The department concurs that freedom of religion, expression, and association are rights that are protected in terms of the Constitution of the Republic of South Africa in the Bill of Rights, but are not without limitation in terms of Section 36 of the Constitution. Any limitation of these rights will have to be tested and must always be justified and complied with in terms of all the requirements in terms of Section 36. Next slide, please. The committee's attention is also drawn to the fact that this particular part in the definition was not a subject matter in the bill. It has been part of the definition of terrorist activity since the adoption of the Principal Act in 2004. The only amendment to this particular part in the definition was the omission of a comma and the insertion of the word "or" in line with technical legislative drafting. Next slide, please. The commentator's recommendation to narrow down the definition of terrorist activity is noted, but is however not advisable. Substantive amendments to the definition that would seek to diminish the definition and that are amendments other than those proposed in the bill will most likely compromise the legislative measures that are currently in place in law to prevent and combat terrorism in the country. Further, if substantive amendments will be made to the definition at this stage in the legislative process, it will have a detrimental effect on other provisions in the bill and may require substantial consequential amendments to other provisions in the Principal Act. The department respectfully requests the committee not to amend the definition outside the parameters of the current amendments proposed in the bill. The definition in the Principal Act, as previously indicated, has been in place since 2004, and only minor amendments are now proposed. Thank you, Chair. That concludes our responses, and we would like to thank the committee for giving us an opportunity to provide responses. Thank you, Chair.
Thank you very much from the department for your response. Before I allow members, if they have questions of clarity, I think we'll allow Ms. Alabak, if she has any comments she would want to make.
Thank you, Chairperson, and thank you, Advocate Kreuziger, for your response. I would say that it is concerning that we've had situations in this country where civil society organizations have been labeled by the executive arm of government as being engaged in terrorist activity. So even though the Principal Act hasn't been used against them, and even though Advocate Kreuziger is of the opinion that the National Director of Public Prosecutions, would not deem a prosecution possible because of the two-legged test for terrorist activity in terms of the Principal Act. It is concerning that the definition contains broad and vague phrases, because this is already the communication coming out of the executive arm when it comes to civil society organizations focused on public participation. So surely Parliament, which is the legislative arm of government, should want to make a law that is not vague and not open to abuse, even if that means building in certain safeguards in the Principal Act to make sure that that cannot happen. And again, the amendments proposed by 4SA, I would say, are minor ones, substantive in the sense that they do affect the content and aren't just grammatical, but they are small and minor amendments that should be quite easy to pass through both houses. Thank you very much.
No, thank you very much, Ms. Alabak. Let me then hand over to honorable members. If you have any questions for clarity, remember that we will deal with our deliberations at a later stage once we are also done with most of the submissions. Honorable Dodovu? Questions for clarity, Honorable Dodovu?
Yes, thank you very much, Honorable Chair. Let me welcome the submission for South Africa and the responses from the department. I have only one question to Ms. Ellerbeck. I think the thrust of what she's raising is the fact that the definition must be narrow so that it is quite clear and it doesn't cover instances or it doesn't suppress freedom of speech from other people. And she further says that in a respective view, she thinks that the current definition is vague. If that is the case, can she provide us with some examples in what way it is vague? Because we don't want the law that is vague, that the public or ordinary person in the street is unable to interpret and understand. If she can, as a way of example, identify those particular areas so that I see them, that this is the exact problematic areas, so that as we move forward, we should look at that as well. Thanks, Chair.
Thank you very much, Honorable Dodovu. Any other member? Honorable Dango?
Thank you, Chairperson. Chairperson, I just want some clarity. Say, for example, there's a situation in Eswatini, and COSATU is mounting protests in South Africa regarding the issues in Eswatini. Where would that fall into the definition broadly? Thank you very much. And thank you, Ms. Ellerbeck, for the presentation that she's made.
Thank you very much, honorable members. Okay, I think the example that FOSA also brings forth in their submission is with regard to the Department of Health, which label civil society organizations involved in enabling public comments on the department's proposed health regulations as instigating terrorism and or sabotage. Perhaps if you could just, because on face value, when I read this, obviously the statement sounds unfortunate, but obviously I don't understand, I'm not familiar with the context of why they made such a statement, but yeah, maybe you could perhaps also give us more in depth in that example. Let me then hand over to, I think, Ms. Ellerbeck, you can comment, and thereafter the department can also comment.
Thank you, Honourable Chairperson. Honourable Dodovu, just firstly, your question about what are the concerns, the vague phrases, you'll find them here. I've bolded them as well. So those you can find, they're examples of some of the vague and broad phrases in the definition. Like I've said, the definition is quite long, it runs over 2 A4 pages, but specifically looking at, for example, serious public emergency or general insurrection. And that is why our proposal is simply to either exclude create a serious public emergency situation or general insurrection, or to actually define what a serious public emergency is and what the criteria are that need to be met for it, or what a general insurrection is and what the criteria are to be met for it. Because again, we're dealing with a lawyer that sends someone to jail for life, or if you help an organization in any way, you go to jail for 15 years. So it's important that we don't sit with vague phrases that are open to abuse. Chairperson, turning to your question, you will find that I actually hyperlinked an article there in our submission, specifically page 2 of our submission, in the footnotes, footnote 2, as an example of that what I've said there about the Department of Health. So I linked it to a news article. Just see if I can share my browser.
No, it's fine. Ms.
Okay.
Bell, I think, no, Ms. Ellerbeck, thank you very much. I think we'll take time and also go through that. But thank you very much.
Okay.
For you.
Thank you.
Okay. Over to the department, Ms. Bell. Advocate Bell.
Yeah, no, thanks, Chair. I just want to say that you know, the comments of the NHI and the health, ideally we shouldn't go that way. If a government official fails to explain certain things, and then they tend to label people who are opposing what they are doing, and we can't use that as a position of government on issues. Really, we can't do that. We mustn't go there. The substantive issues raised, yes, we can talk to that. Maybe I can allow to talk to that. I just thought this matter of health should not even be an issue. It's unfortunate that that official said those things. Our constitution is very clear. Anything that infringing on the constitution can't be allowed. It's illegal. So I thought I must just say that. Thanks, Chair. Advocate Kritzing.
Advocate.
Thank you, Deputy Minister. Yes, in relation to the example that was asked about the COSATU actions, it is very difficult at this stage to, if you don't have all the circumstances and facts of the particular action, to give a clear response. But the issue is that any act that is committed in such a case must always be tested against the definition of terrorist activity. First of all, it will require an act that is by nature violent and is aimed at endangering the life of people, the integrity of persons, might cause damage to infrastructure, might cause sabotage or whatever. And then secondly to this act, and there's no alternative, there must be an addition of a particular intention. And the required intention is something that must be proven by the state. And it relates to something that might cause a threat to the unity or the territorial integrity of the Republic, to induce or to cause feelings of insecurity within the public or a certain segment of the public, you know, things like that. So all activities must always be tested against the two elements of the terrorist activity definition to establish whether in fact it can be regarded as a terrorist act or not. Thank you, Chair.
Thank you very much to the department and to Ms. Alabak for that engagement. And thank you once again, Ms. Alabak, for your presentation to the committee and for your response to the bill. I'm not sure if I welcomed you, and my apologies if I didn't, but it's never too late to welcome you to this meeting. I think there were a bit of interruptions in the process, but being that is made, also feel welcome to this meeting. But thank you very much for your presentation. Our members will then move on to the next representation by the Cape Independent Party. Let me also welcome the organization to the platform. I think it is it Mr. Miller who is on the platform? Okay. No, thank you very much, Mr. Miller, because I know your full name is not here. Welcome, and let me then hand over to yourself to make your presentation. Mr. Miller.
Thank you very much. Thank you, Chair. Can you hear me?
Mr. Miller, you are breaking a bit. I hope it's not just me, but maybe it's advisable if you also turn off your video. But just speak. Can you speak, and then I'll tell you whether you still.
Yes, Chair. Can you hear me now?
Yeah, that's much better. Please continue, Mr. Miller.
Okay. What? Thank you. So let me just start by saying thank you very much, Chair, and thank you to this honourable committee for their time today. I want to say that I personally have adopted a slightly different perspective to this than I have in the time leading up to this presentation. I was under the impression that this bill was put forward exclusively by the ANC, but I'm very heartened to see that the concerns that we have at the Cape Independence Party is actually shared by a number of members of this committee. And so I'd like to begin by just quoting some of the members of this committee in the previous meeting on the 30th of November. If I can quote the Honorable Mr. Mikalakis, saying he was becoming increasingly uncomfortable with the way that the committee was being forced to deal with the legislation, as this was the second bill where significantly short deadlines had been given by outside parties. This committee could not apply their minds to legislation of this nature in the way it was currently being required. He was uncomfortable with the way that the NCOP had been treated, regardless of political affiliation. They had been expected to rush through this legislation. Further on in the meeting, the Deputy Minister said that note had been taken of the issues that the committee had raised. Sorry, let me go back. He asked the chairperson to take this issue up with the chairperson of the NCOP, as the NCOP's work is important, and it had a constitutional mandate to ensure that decent legislation was passed through Parliament. The chairperson noted these issues and said these concerns had been raised, in fact, by other members at a personal level. She too had raised these concerns with the Chief Whip and the House Chair, and would perhaps elevate these matters to the chairperson of the NCOP. The Deputy Minister said that the note had been taken of these issues and they will be raised through the proper channels. These concerns would be addressed to ensure that the NCOP was not forced to work under duress. It was important for the NCOP to process the legislation to ensure that South Africa was not left in an undesirable position. The chairperson thanked the Deputy Minister and his team for their presentation and response to the committee's concerns, and noted that her question concerning the financial implications of the bill had not yet been addressed. So if I can use those comments to just depart from our concerns, is that we fully appreciate the pressures involved with the danger of being grey-listed by the FATF. But at the same time, South Africa is a sovereign nation. It has democratically elected leaders. It has a constitution, and it has a population who votes for its leaders to fight for and represent their best interests in government. I think that we should not put the will of the people, the concerns of citizens, and the constitutional rights that we as South African citizens share. We should not make this subordinate to the pressures of external forces. I sympathize with a number of the points that were raised by Ms. Ellerbeck from Forsa, and also appreciate the comments made by the Honorable Daduvu and Honorable Matale, in that we cannot have vague clauses in the law, and it needs to be comprehensible to the person on the street. So let me then turn to the presentation, which I hope some of you have had the opportunity to read. And if I can go through it point by point, hopefully we can clarify the concerns that we at the Cape Independence Party have, as well as the many different organizations who have supported this objection and provided their inputs too. I would just like to, before I do that, also say that I will do the best to present this issue without prejudice, to the best of my ability. However, everything that I say today is without prejudice. It is without prejudice to the Cape Independence Party. It is also without prejudice to all of the organizations listed in this objection. In the event that there will be future legal proceedings, my comments here should not negatively impact any future legal proceedings if that so happens. We obviously hope that future legal proceedings can be avoided, and that here in this committee, we can ensure that the concerns that we're raising will be addressed and that we can bring these amendments in line with the South African Constitution. Dear Select Committee on Security and Justice, we write to you on behalf of human rights activists, South African citizens, and or organizations that believe in, advocate, protect, or promote the right to self-determination. We believe that the amendments in their current form leave the door open for misinterpretation of the Act in such a way that individuals or organizations that protect or promote the right to self-determination in South Africa could be classified as terrorists. Over 25,000 South African citizens and organizations have lodged objections to many of the proposed amendments to the Act. We do not believe that these objections were appropriately addressed and that the bill in its current form is unconstitutional. Our primary concern revolves around the removal of Chapter 1, Subsection 4 on self-determination. We are concerned that removing Chapter 1, Subsection 4, which defines and protects the constitutional right to self-determination, could be incorrectly interpreted as terrorism. We note that the Red Cross, Dear South Africa, as well as AfriForum, amongst others, have also raised serious concerns surrounding the dangers of the removal of the subsection as provided below. This part of the law states that any groups that would be, sorry, let me just begin from the start there. So notwithstanding any provision of this Act or any other law, any act committed during a struggle waged by peoples, including any action during an armed struggle, in the exercise or furtherance of their legitimate right to national liberation, self-determination, and independence against colonialism or occupation or aggression or domination by alien or foreign forces, in accordance with the principles of international law, especially international humanitarian law, including the purposes and principles of the Charter of the United Nations and the Declaration on Principles of International Law concerning friendly relations and cooperation among states in accordance with the said charter, shall not, for any reason, including for the purposes of prosecution or extradition, be considered as a terrorist activity as defined in subsection 1. This entire section has been taken out, and that is incredibly concerning. This section was intentionally included in the original Act under definitions and interpretation. This was done for the exact purpose of making it clear to all, the public and the courts, that self-determination is not to be defined or interpreted as terrorism. There can be no logical reason to remove this section. Its removal creates confusion within the intent of the law and thereby suggests that acts of self-determination could in fact be confused as acts of terrorism. Since its very inception in the Act, Chapter 1, Subsection 4 has helped to define the law surrounding terrorism and to help ensure that acts of self-determination are not misinterpreted as terrorism. It therefore provides clarity and the correct interpretation of the law. Nothing is gained by its removal. Its removal is arbitrary and dangerous, as it could lead to the prosecution and persecution of acts protected in the Constitution, such as self-determination. Therefore, we propose that it must not be removed. To reiterate the extent to which self-determination is to be protected, defended, and guaranteed in law, here are a few both South African and international laws which protect it. The African Charter on Human and People's Rights, the United Nations Charters, Article 1 of the International Covenant on Civil and Political Rights, the 1948 Universal Declaration of Human Rights, the 1966 International Covenant on Economic, Social, and Cultural Rights, and the Covenant on Civil and Political Rights, known as the Twin Covenants, and Section 235 of the South African Constitution, which is also binding the South African government to international law by sections 39.1, 231, 232, and 233. So in complete opposition to those above laws I've just listed, the removal of subsection 4 does not strengthen the definition of terrorism as the bill was intended to do. Instead, it weakens the definition, it provides less clarity, and it creates confusion amongst the public and potentially courts in the interpretation of the law. If there is a specific part of the subsection that the committee is concerned with, then that specific part should be addressed. But removal of the entire subsection protecting the right to self-determination goes against the intended interpretation of the law and may result in conflict with section 235 of the South African Constitution, as well as the charters of international law previously mentioned. Some of the other knock-on effects that make this problematic is the South African Police Service is knowingly overburdened in terms of manpower and resources. By removing this subsection, individuals and organizations that are promoting the right to self-determination, and in many cases have been doing so legally and peacefully for many years, may all of a sudden be misconstrued as engaging in terrorist activity. This could misdirect and overburden SAPS even further in the pursuit of inappropriate claims of terrorism, and even worse, could illegitimately classify law-abiding citizens and organizations as terrorists. In the limited time that we have available to meet the deadline to submit objections as provided for by the committee, and I might add here too that this is a concern raised by the committee itself. We and those who have objected with us will not be able to compose a comprehensive list of all of the legal problems with interpreting the powers envisioned in the old act, taken in the context of the removal of any substantive recognition of and protection for the right to self-determination, or the broad concerns related to the blatant government overreach implicit in many of the new amendments proposed. So in this regard, this objection is not exhaustive, and we reserve our right to expand on this and object to any further such matters in the future. However, as a matter of urgency, we will attempt to address the issues we believe must be addressed without any further delay. In the amendments B15B, page 6A, IIIA, it states that terrorism is any act which is calculated to overthrow the government. This was also a phrase which Ms. Ellerbeck from FORSA identified as being problematic. Such terms as overthrow are left open to interpretation without any context of self-determination. So, for example, this could result in the most basic democratic process of a political party in favor of self-determination, electorally defeating or overthrowing the national ruling party, and this could be interpreted as an act of terrorism. Furthermore, the above peaceful political acts taken in conjunction with page 7, BI, which states, terrorism is any act which threatens the unity or territorial integrity of the Republic. This could also misconstrue self-determination as terrorism. And on page 7, BII, the net is cast so unreasonably wide as to include the sharing of any ideas which may cause feelings of insecurity in a person, government, or institution. That is incredibly broad and incredibly concerning if there is no form of definition and protection to the interpretation of acts which fall under self-determination. The above is then made even worse on page 7C, where it confuses matters further by stating that terrorism is any activity, as contemplated above, which is committed for the purpose of the advancement of a political, religious, ideological, or philosophical motive, objective, cause, or undertaking. That is so incredibly broad and covers organizations such that FORSA represents and such that we too represent, and voters and citizens who support such organizations could be declared as terrorists. This is incredibly concerning. I might add here too that a lot of these organizations don't necessarily have control over all of their members. And in one of the points that was raised earlier today by, I believe, Ms. Kritzinger, she referred to there needs to be an aspect of violence, and this too can unfortunately be rather vague. It's quite possible. She mentioned that the National Director of Public Prosecution would be the essential protection to make sure that such matters wouldn't be incorrectly labeled as terrorism. But I would like to add that this is in fact maybe more dangerous. The current National Director of Public Prosecution may have the perfect intentions to uphold the law in a matter that they deem is consistent with the South African Constitution. However, if any future Director of Public Prosecution was to be convinced that a more dictatorial approach should be taken, essentially such powers would be resting in the hand of one individual, and this is incredibly dangerous. To expand further, the principles of international order were set out in a 2018 report to the General Assembly of the United Nations and the Human Rights Council. Section 14H of this categorically states that the principle of territorial integrity has external application, and the state cannot use the principle of territorial integrity to deny or hollow out the right to self-determination. It is as if the above amendments have been constructed either with malicious intent or without any understanding of the right to self-determination, the right to free speech, political protest, and a basic principle of democracy, which is to protect the right to a plurality of opinions and opposition voices which keep a government robust and accountable. The above is obviously not an acceptable outcome or interpretation, but one that becomes possible with the inclusion of ambiguous and broad definitions and by the removal of any reference to the right to self-determination. It is well known that the right to self-determination was specifically signed and agreed upon by the President of South Africa, Thabo Mbeki, as well as Constant Viljoen of the Freedom Front, and its principles have been promoted by many political parties and organizations in the country over the years, such as the IFP and others. The Cape Independence Party has been officially and legally registered with the IEC since 2007. We are democratically elected, hold seats in government, and have been peacefully promoting the principles of self-determination and contesting elections in South Africa for over 15 years. Similarly, parties like the Cape Coloured Congress, the UIM, organizations like the CIAG, ULA, Cape Exit NPC, UCSCTA, CIG, SSOGH, amongst others, have all been legally promoting the right to the self-determination of the Cape. To provide yet more examples, organizations like Dear South Africa and the recently formed Western Cape Devolution Working Group, which include organizations such as the DA, ACDP, Freedom Front, ourselves, AfriForum, Cape Forum, SACALIGA, SAI, as well as many internationally renowned and well-respected economists, lawyers, and businessmen who all believe in forms of self-determination, such as federalism or devolution. The danger and absurdity of the proposed amendments to the Poctatoro Act is that if enacted in its current form, all of the above organizations and their supporters could now potentially be classified as terrorists. If this is the intention of the amendments to the Act, then the national government of South Africa would be openly stating to its citizens and the world that South Africa is no longer a constitutional democracy, but rather a one-party tyrannical dictatorship. I would like to amend that based on what I mentioned in the opening of my presentation, that we're deeply concerned that, in fact, this is not necessarily an ANC proposed agenda, but rather one that comes outside of the borders of South Africa. And certainly the South African Constitution should be held first and foremost of the utmost importance and the will of South African people. So the fact that 25,000 objections have been submitted from the South African public should let us know that there is a concern here. So the above is surely not the intention of the proposed amendments to the Act, and hereby we kindly request the Select Committee on Security and Justice to reconsider the proposed amendments to ensure that the right to self-determination remains in the Act, that any ambiguity is removed, which may threaten South African democracy, free speech, the right to report and share information freely, protest the government, and to oppose its policies if need be. Sincere regards on behalf of the Cape Independence Party, the Cape Coloured Congress, the UIM, Dear South Africa, the CIAG, the CTA, the ULA, Cape Exit NPC, Cape Independence Forum, Victor Legal, the Cape Independence Group, and the Greater Cape Town Civic Alliance and the Cape Independence Movement. Thank you. That brings me to the end of our submitted objection. What I would like to then move into, when I was speaking to Mr. Dixon in the days leading up to this, I asked him if I could open with a question. He said it would be preferable if we rather present our case. And then following that, we can discuss it. So the question I was going to ask is why? Why has the clause on self-determination been removed? But in some of the research that has been done in the days leading up to this, we see that, as was mentioned earlier, that these proposals and amendments have been put forward as a result of pressure on South Africa from the FATF. And if the concern is to meet the requirements put forward by the FATF to avoid grey listing, then let us look to the FATF and the concerns that they have with this specific clause on self-determination. I believe it is page 165 on the FATF recommendations to South Africa. Criterion 5.1, recommendation 5 on terrorist financing offenses. The protection of constitutional democracy against terrorist and related activities, number 33 of 2004, Paktatara, came into effect on the 20th of May, 2005. And it contains several offenses related to terrorist financing. Generally, the criminalization of terrorist financing in South Africa is broadly consistent with most of the TF Convention. The Paktatara, however, does exclude from the definition of terrorist activity certain acts committed during an armed struggle. This exemption therefore narrows the scope of the TF Convention. Article 6 of the TF Convention states that each state party shall adopt such measures as may be necessary, including where appropriate domestic legislation, to ensure that criminal acts within the scope of this convention are under no circumstances justifiable by considerations of a political, philosophical, ideologic, racial, ethnic, religious, or other similar nature. So when we look at the amendments that the FATF has proposed to South Africa, it specifically revolves around the concern that acts committed during an armed struggle would be exempt from terrorism. And so from our point of view, we believe that this is in fact a reasonable request from the FATF. We do not have a concern with that particular issue that they've raised. And so we would like to propose then to the committee that the Chapter 1, subsection 4 is retained. However, if the committee deems it appropriate to remove the sentence which states acts committed during an armed struggle that would not be protected under the rights to self-determination, we believe that would satisfy the requests of the FATF and hopefully would meet the approval of this honorable committee, and we believe would satisfy the concerns of the various groups which support self-determination in the country, as well as ourselves. Thank you very much.
Thank you very much, Mr. Miller, for your representation. Let me then hand over to the department for their responses. And then Mr. Miller will allow you a bite as well.
Thank you, Honourable Chairperson. I'm going to provide the department's responses on the submission by the Cape Independence Party. Slide 18, please. Thank you. Chairperson, we have again summarized the comments that we've received from the commentator, and I'm going to just take the committee through them. The Cape Independence Party has objected to the deletion of section 1.4, as it will create confusion and possibly lead to individuals and organizations that protect or promote self-determination to be classified as terrorists. This section assists to define the law surrounding terrorism and ensures that self-determination is not misinterpreted as terrorism. References in the definition of terrorist activity as any act which is calculated to overthrow the government or which threatens the unity or territorial integrity of the Republic can be misconstrued as terrorism in the context of self-determination. Next slide, please. Chairperson, in terms of our responses, we need to indicate that Section 235 of the Constitution of the Republic of South Africa recognizes the collective right of South African people to self-determination. Communities have rights to pursue self-determination in line with this collective right. Whilst the Bill of Rights protects basic human rights such as right to life, the right to freedom, and security of the person, it does not protect the right to self-determination. It follows that the right to self-determination cannot be protected at the cost of human rights enshrined in the Bill of Rights. For an act to be regarded as a terrorist activity, there has to be a link between the act that can cause harm and the intention to achieve the objectives. Any organization that pursues the collective right to self-determination in a peaceful manner would under no circumstances perpetrate any of the actions described in paragraph A of the definition of terrorist activity, and would therefore never be in a position where it could potentially be considered to be involved in terrorist activities. Next slide, please. It should be noted that the activities described in paragraph A of the definition would in itself be regarded as very serious offences, and if pursued in the exercise of the right to self-determination, would not be a defence against those offences despite Section 1.4 of the Principal Act. Section 1.4 of the Principal Act does not protect an organisation that pursues self-determination through the commission of the acts mentioned in the definition, through means that threaten or harm civilian populations or non-military combatants from a charge of terrorism. Such acts would not constitute a legitimate pursuit of self-determination in accordance with the principles of international law, especially international humanitarian law. Chairperson, so in conclusion, we can say that Section 1.4 does not protect the right to self-determination and does not provide immunity for criminal liability for anyone who pursues the right to self-determination in a manner that constitutes a criminal offence. The deletion of Section 1.4 does therefore not mean that people would now be prevented from pursuing the right to self-determination in a manner that would previously have been allowed by the law. What it means is that a group that pursues the right to self-determination in an illegitimate manner, could also be charged with terrorism if their intent is to achieve the outcomes referred into paragraph B of the definition as I referred to earlier. Thank you, Chair.
Thank you very much. There was a second point as well that was raised by Mr. Miller. Will the department respond to that now with regard to acts committed during armed struggle? Advocate Bell or Advocate?
Chairperson, yes, the department received the submission late last night, and this question wasn't raised in the submission. So we respectfully request that we be given that to us in writing, and then we'll respond to it if the chair allows. Thank you.
Okay. Okay. No, that's okay. Let me then, with regard to the objection that was raised in your written submission, Mr. Miller, if you have anything you would want to raise, Mr. Miller.
Yes, Chair, thank you. And thank you to the response from Ms. Kritzinger. Our concern ties in also with Ms. Ellerbeck and Forster, that because a lot of these definitions are so broad in what Ms. Kritzinger just raised, terms like may cause harm or intention or illegitimate, these are the types of terms which the law would be depending on whether to prosecute someone as a terrorist or not. And as mentioned earlier, there are certain parts of this this Paktatara Act which states that feelings of insecurity, the mere action of causing feelings of insecurity, could be determined as causing harm. And so with such a broad definition, we would certainly feel more comfortable if the simple offensive term, I believe, is the term which says committed during an armed struggle. We would certainly feel more comfortable that if that part was removed, then, and the rest of the references to self-determination remained in the act, because we believe there's a reason. It wasn't arbitrarily, this section on self-determination wasn't arbitrarily included in the Paktatara Act in the beginning. It was put there to clearly define, and the fact that it stands in the definition and interpretation section means it was put there to assist the courts and to assist the public with how they define and interpret terrorist activity. And so the intention would have been to make sure that acts of self-determination are not confused with terrorism, and that is specifically why it was included in this bill and in this act. So we wouldn't want to take actions that would be negative to the positive law that was created almost 20 years ago. And we believe that the legislators who put that law into effect almost 20 years ago knew what they were doing. And we would respectfully like to make sure that those intentions are maintained. And thank you for the suggestion to put that into writing. I will certainly do so, and we will send that through to the committee as soon as that's completed. Thank you very much.
Thank you very much, Mr. Miller. If you could perhaps do that today, and I think we are going to continue with our public hearings tomorrow. You are also most welcome to be part of that process tomorrow. So let me then see, honourable members.
Thank you very much, Chair.
Honourable members, are there any questions for clarity? Honourable Dodovu?
Thank you very much, Honorable Chair. It is always very good and interesting to listen to other perspectives, whether you agree with them or not. But it is very, very good, and it is in the nature of our South Africanness to tolerate other views, to accept them and allow people to freely express their views in the way that they want to, as long as that is within the boundaries of our Constitution. Now, just two questions from my side. to Mr. Miller. Firstly, my understanding is that the right to self-determination is properly encapsulated in our constitution in terms of section 235 of our constitution. It is there that people have got the right to promote their own culture, their own language heritage, and all of that. And there's no question about the fact that this is entrenched and protected in our constitution. Now I want Mr. Miller to share with us, if possible, some practical experiences where this right to self-determination threatens people, especially when it relates to Section 2 of our Constitution, because Chapter 2 of our Constitution, deals with a whole range of rights that are protected, subject to their limitation in terms of Section 36. Maybe if you could share with us some practical problems that you think they will arise if this is not returned into the Amendment Act. For me, this is quite important so that we mustn't just talk without a clear evidence that this, if it is not done, it will create serious problems going forward. That is the first question, Honorable Chair. The second question, yes, part of the reason why we are doing this amendment, it is because of the FATF's recommendations to us to request us as a country to look into our own processes, including the laws, so that they are compatible with the international trends and that we are not gray listed. There is no question about it. And that is why we are doing this. Now, I that's my understanding, and please correct it. I've not seen where the FATF is saying to South Africa, you have a particular problem in respect of self-determination, or this particular aspect becomes a major concern for the FATF to an extent that if we do not insert it in the way that Mr. Miller is proposing, this will create problems for us. That's my question, and I want him to, if possible, Honorable Chair, to address the committee on that particular aspect as well. Thank you very much.
Thank you very much, Honorable Dobu. Mr. Miller, if you could respond to that, and then the department will follow. Thanks.
Thank you, Chair, and thank you, Honorable Dodovu, for your questions. Let me start with your first question. I think a good practical example of where something that those who are promoting self-determination in South Africa, some problems which might arise, is how the courts might determine and interpret these terrorism amendments with the South African Constitution. And if we look to the history of South Africa, we have two very good examples of where the territorial integrity of South Africa has in fact changed just in the last 50, 60 years. And the term threatens the unity is also a very vague term that we now find in the amendments. And if we look back to 1966 and 1968, under the apartheid regime, you had the the territories of Lesotho and Swaziland at the time, coming to an agreement, Lesotho in 1966, Swaziland in 1968, where they said, we don't like the way the government is treating us. We were previously autonomous prior to 1910, and the people of Lesotho and the people of Swaziland decided that they would rather be self-governing states. And so when we look at the map of South Africa today, we have these two holes in the territorial integrity of South Africa, these two independent countries, Lesotho and Swaziland. And based upon, we believe, these amendments, that the actions of Lesotho and Swaziland, let's assume they were still part of South Africa today, if they were to pursue self-government, that could be classified as terrorism according to these new amendments, because that would threaten the unity or territorial integrity of the country. And that's obviously something that Lesotho and Swaziland would not be very pleased about. So I think that would be a real life example of where, under the certain previous political government in South Africa, where this right to self-determination was actually pursued and enacted. But under these amendments, something like that would be classified as terrorism. And I don't think that that is acceptable and wouldn't be in line with Section 235 of the South African Constitution. To answer the Honourable Dodovu's second question with regards to the FATF, their concerns or their potential concerns with self-determination.
Okay.
I beg your indulgence. Honourable Chair, I wanted to make a follow-up, if I may, before he gets into the second question. Otherwise, I'll miss what I want to raise.
Okay, Mr. Miller, can you bear with us, please? Mr. Miller, Mr. Dodovu, please continue.
Yes, I'm saying that.
Yes, of course. Yes,
and I don't. This is a question session, and without debating, and I'm not here to debate for now. I just want to get clarity so that at the time that I engage in the discussions, I should have fully understood where you're coming from. I'm saying, other than the practical examples you are giving about Lesotho and Swaziland, since the advent of our democratic dispensation, there was never such a thing, or since the Datara Act was promulgated in 2004, there was never such incidents that pertains to self-determination in the way you're giving examples. The only things that come to my mind, it is the case of the Burema. I'm not even sure that it was prosecuted in terms of the Datara Act, but it is the case that I can highlight. The other one pertains to those people who had some ill intentions during the Mangaung conference of the ANC in 2012. And those are the specific incidents and examples that I'm putting forward. Now, my question is, since the advent of the new democratic dispensation in 1994, or since the promulgation of the Datara Act, there's been any examples where this concern will arise to an extent that it should create a red flag on our part, and we should be worried and feel very much strong that this particular proposal you are making, we should insert it in our Amendment Act. Thank you very much, sir.
Thank you very much, Honourable Dodovu. Mr. Miller, perhaps respond to that before we go to the next question.
Yes. I think the very fact that self-determination has been recognized in the Datara Act since its inception is perhaps part of the reason why there hasn't been any problems. Just to add to another example there, Honourable Dodovu, there's also the case of the Abatembu tribe in the Eastern Cape that were calling for self-government of the territory that they inhabit. So we believe that the Act, as it's currently written, doesn't pose any problems. I think the fact that self-determination is mentioned there is a good safeguard and a protection of Section 235 of the South African Constitution. And we see no reason to remove it because we believe it's done a very good job over the last 2 decades and we believe it will continue to do a good job of ensuring that Section 235 of the South African Constitution is in fact respected, as well as all of the other international law that we've spoken to. The concern here is that if that entire section is removed, it starts to create the premise that actions that would previously have fallen under legal and peaceful acts of self-determination could be misinterpreted as potentially overthrowing a government, causing feelings of insecurity, what's the other one? Threatening the unity, threatening territorial integrity. These terms all of a sudden become dangerous terms if one removes the reference to self-determination. So to tie that in with your second question, so yeah, there hasn't been an issue. There has not been an issue since the new South African dispensation, and we believe there hasn't been an issue because the laws have been good up until this point. I hope that answers your question. And then to get to your second question, we don't know if the FATF, well, what we do know from reading their documents is that the FATF's concern is specifically with the term that states, any act committed during a struggle waged by peoples, including any action during an armed struggle. That appears to be what their primary concern is. The sentence that says, including any action during an armed struggle. So we believe that if violence is removed, if that sentence referring to an armed struggle is removed, then we believe that would satisfy the requests of the FATF, because then no acts of violence would be acceptable, be it under self-determination or any other action, which we accept as a completely reasonable request. And so I think we can satisfy the demands and the requests of the FATF by removing that one sentence, which says, including any action during an armed struggle. And we think by doing that, that will then still balance the recognition and the protection of the right to self-determination, but at the same time, remove the concern that the FATF had. I hope that answers your question. Thank you.
No, thank you very much, Mr. Miller. Honorable Dodo, I hope you covered for now. Let me then, because I see your mic is unmuted, perhaps muted as well. Okay, let me then hand over to the department.
Thank you, Chairperson. Yes, I just need to indicate that the repeal of Section 1 must be understood within the context of international law. The Boktatara must be aligned with the Geneva Conventions, Protocols 1 and 2 relating to the protection of victims of international armed conflicts and non-international armed conflicts, respectively. Subsection 1.4 only constitutes a defense to a crime of terrorism contained in Section 2 of the Principal Act, which is the offense of terrorism. Section 1.4 does not apply to the convention offenses, including the offense of terror financing. As it currently stands, an accused cannot even rely on it to avoid conviction under Section 4. With specific reference to subsection 1.4, South Africa were found to be partially compliant on implementation, and this contributed to the rating of low and the low level of enforcement of terrorism financing by South Africa. Given the severe consequences if a peer review shows that FATF members is unwilling to implement the recommendations, and it will be detrimental to South Africa because this will make us to be put on the grey list. With the deletion of subsection 1.4, the crime of terrorism will still require the commission of a terrorist act coupled with a terrorist intent and the intention of intimidating the government of the day or the civil population. It will distinguish it from other crimes of violence and will still comply with our international guidance. Thank you, Chair.
Thank you very much, Advocate Kritzinger. Okay, honourable members, I think before we move on to the next representation by Dr. Schoeman, I think Ms. Alabek just requested to make a comment. I know Ms. Dr. Schoeman, my apologies, I know we are running a bit late, even though we had, there was one participant who was not making any representation today. But if you could just bear with us a little bit, and my apologies for that. Ms. Alabek, you indicated that you wanted to raise one issue. Please continue.
Yes, thank you, Chairperson, and thank you for the indulgence, Dr. Schoeman. I just wanted to clarify and make sure that I was clear in my answer to the department with regards to Advocate Kritzinger, who said the two-legged test would be sufficient to protect against, any abuse of the vague phrases. So I'm just sharing the screen here of the bill. So here we see leg 1, for example, terrorist activity means any act committed inside or outside the Republic in which, for example, and here's a vague phrase that's being put in, is calculated to overthrow the government. Another vague phrase, this is the one that already exists in the Principal Act, creates a serious public emergency, undefined, no criteria, no direction, undefined, no criteria. Okay, and then we scroll down and we see leg 2, and which is intended, or by its nature and context can reasonably be construed, regarded as being intended in whole, in part, directly or indirectly to. And here we see the bill inserts further the objectives of an entity engaged in terrorist activity. So what we see here is we've got the vague phrases that are undefined with no criteria in leg 1, and we see leg 2 inserting the phrase further the objectives of an entity engaged in terrorist activity, which is the circular reasoning I was talking about. So all I wanted to point out is that it's concerning because so you meet the two-legged test for terrorist activity if you cause a serious public emergency or a general insurrection, which are undefined, no criteria, and this furthers the objectives of the organization. That's a very it's not a strong two-legged test is what I wanted to say, and I just wanted to make sure that came across clear for the committee. Thank you for the indulgence.
Okay, thank you very much, Ms. Alabek. I think we'll note your concern. Let me then go to our third presentation by Dr. Schoeman, who's presenting on behalf of the Sussex Terrorism and Extremism Research Network, STERN for short. Over to you, Dr. Schoeman.
Thank you so much, Honourable Chair. Good morning, Honourable Members, Honourable Deputy Minister and colleagues. Thank you so much for this opportunity to speak with you today. I'm always very impressed with South Africa's deliberative process, so I'm very glad to be able to speak to you today. A little bit about us. I wrote this submission based on some work with my colleague, Dr. Matthew Garrett, who's a researcher at the University of Sussex, as well as an independent expert advisor on counterterrorism and organized crime at the United Nations. Myself, I've worked on projects for the Brookings Institute, UNODC, UNDP, the World Bank, and previously worked for the Institute for Security Studies, where I advised various African countries on human security issues, including counterterrorism, and I worked on the development of 2 regional counterterrorism strategies in East Africa and the Great Lakes region. I'd like particularly to focus today on the one issue around the prohibition of unlawful terrorist content. This is a bit of a different angle to what we've heard previously. I've gone in quite a different direction. But let me first start by talking about the context of violent extremism and terrorism in South Africa. We've mentioned some of these groups before today, such as the Boeremag. To answer a question earlier around whether they were prosecuted under Poktatara. This was actually prior to what we had Poktatara, and they were prosecuted under terrorism charges. So we have two types of groups or categories that we can think about: domestic groups such as Buramach and People Against Gangsterism and Drugs, or Bagat, both of which engaged in terrorist acts in South Africa, and their members were charged. And then we have international linkages to groups such as Al-Qaeda, Al-Shabaab, and Islamic State. And we see here instances of where individuals linked to these groups have hid out in South Africa to avoid prosecution and capture, or have used their networks within the country to gather finances to perpetrate acts abroad. And in some instances, these same groups have tried to threaten South Africa itself. The most famous case that we have in South Africa of international terrorism is the Henry Oka case. Henry Oka was a Nigerian national who organized weapons smuggling and planned terrorist activities in Nigeria from South Africa. And he was charged under Poktatara, which showed the strength of our National Prosecuting Authority and this legislation to deal with complex criminal cases. And there's some very interesting things that came out of the Poktatara case, as this ultimately went to the Constitutional Court. And this dealt quite a bit with what we've just talked quite a bit about, subsection 4 on national self-determination. And Mr. Oka, in his appeal to the Constitutional Court, tried to raise this defense of national self-determination because he was advocating for the independence of groups within the Niger Delta of Nigeria. Ultimately, our Constitutional Court ruled that that phrasing in subsection 4 was unclear and difficult to interpret, and that it wasn't contributing towards our understanding of a terrorist act, because ultimately we have to understand, as Advocate Kritziger has explained today, the two parts of the definition, part A being the commission of a violent act, and part B related to the coercion or threat of violence, trying to compel a government to do a certain activity. So our Constitutional Court has itself said that the subsection 4 on national self-determination is very problematic. And then I'll turn to some of the questions around the Financial Action Task Force, or FATF. The challenge that we have here with subsection 4 and FATF is that this particular inclusion of this loophole of national self-determination means that when you try to apply this to countering terrorist financing, this creates a potential loophole in terms of the conviction of people who are supporting these types of groups. If I can give one example that we've seen internationally, when the Americans first started countering terrorist financing, one of the issues that they found out about, they'd been thinking a lot about groups such as Al-Qaeda, but they realized that there were a significant amount of Irish Americans who were providing funds to the IRA in the Republic of Ireland and Northern Ireland who were committing terrorist acts. And this was in fact prolonging the war. So FATF's point here around the removal and the potential challenges that we have with subsection 4 relates to this issue of prosecuting terrorist financing. And this is really something that we should take into account because it is an important and unnecessary loophole that has been included here. Our definition of terrorist activity has largely been based on the Canadian definition, and they've had a very similar Constitutional Court hearing where one of their convicted offenders tried to take up issue with the definition of terrorist activity. And this individual focused more on the ideological and religious motive that there have been some suggestions to include in our definition, but which have ultimately been removed precisely because they are problematic. And in this case in Canada, the Constitutional Court made a very similar judgment to what we saw in South Africa, that the important aspects to consider are not the religious or ideological intent, but rather the commission of a violent act, part A of the definition, and part B, the intimidation or coercion of the government. Another important thing beyond FATF's recommendations to recognize is that I think it was in 2018, we had CTED, the Counterterrorism Executive Directorate, which is an institution within the UN Security Council, conducted a review of South Africa's counterterrorism legislation to provide recommendations on potential changes. And a lot of what we are dealing with today stems from that. And this is trying to deal with the nature of international trends in terrorism that we see right now. So this is issues around foreign terrorist fighters. We've seen South Africans that have left to Syria and Iraq to join the Islamic State and commit atrocities there. Similarly, we have issues around online content with young people in South Africa and around the world that have been radicalized through material that is shared online, that is used to groom them into this terrorist type of thinking and leads them to commit these types of activities. And we have seen this in South Africa as well. I mentioned here the issue of the Tutsi twins, which were recently convicted under POC-TOTARA. And in this case, you can see that they were allegedly groomed by online individuals who, I guess, inducted them into this violent extremist thinking and encouraged them to perpetrate acts within South Africa. Fortunately, in this case, we were able to intercept this from happening. And fortunately, we didn't have any terrorist acts occurring. But we've similarly seen many other South Africans that have, through this online interaction with individuals and through reaching out or reading problematic content that is promoting these types of acts, that have joined these groups and that contribute financing towards the perpetration of their terrorist activities. In 2017, we similarly saw 2016, when the Tutsi twins were arrested, there was another case of teenage girls who were on their way to Syria, but were fortunately intercepted. And once again, they were indoctrinated through this online content and their interactions with very problematic people that were trying to get them to join the Islamic State. Now, we've also seen this issue come a lot closer to home with the conflict in northern Mozambique, in Cabo Delgado. We know that there are South Africans that have in fact joined this conflict. There are individuals linked to the Tutsi twins, some of their associates that left South Africa to join this conflict, and there's always a threat that they would come back again. So Advocate Kritzinger has done quite a bit of my job today, because I was going to talk quite extensively around the definition of terrorist activity, and because this is very important for understanding any kind of legislation that we would like to impose around the prohibition of unlawful terrorist content. This is something that was originally included in the proposed bill, but in the process of deliberations within the Portfolio Committee for Police, this specific clause was removed. And I think that that is a mistake and that we should return this because we know that there are real threats to South Africans being radicalized by this online content. And as I'll argue today, I think there are very appropriate safeguards to prevent the abuse of this type of legislation. So turning to the definition of terrorist activity, I think we've heard a lot today that this is overly broad. It is a long piece of legislation or definition, but that is precisely because it is trying to be so specific and trying to build in safeguards to say under which circumstances it would be inappropriate to consider something a terrorist act. There's a very long history of the development of this legislation. Back in 2002, when this process first started, when we first started looking at POC-TOTARA or a similar kind of legislation, there was over 1,000-page report prepared by the Law Commission. And we've looked extensively into international examples of definitions around terrorist activities and what would be appropriate for the South African context. And I think we've done quite a good job of that. There is an excellent presentation that was done by Dr. Jacobs to the Portfolio Committee on the terrorist activity, which explains this whole history, how the terrorist activity definition functions. And Advocate Kritzinger has alluded to a lot of these issues here today, and I think has explained this quite well. But let me give you my interpretation of this as well. As Advocate Kritzinger said, there are two important parts to this definition that we have to consider, and they have to be read together. You can't take parts of definition B and say they are vague or problematic. You have to acknowledge what is the act that is happening in part A. So there's always the part A, which is generally a violent act or a convention offense. And there is some references to an interference or disruption of economic activity, which I will come back to later. And then the part B around threatening, intimidating, or coercing the government into a particular action. And when you read these two parts together, you get to a proper definition of terrorist activity. You can't say that part B says that threatening the unity of the Republic is a terrorist activity. What you have to understand is that committing a violent act to threaten the unity of the Republic is considered a terrorist act. You can't read them separately. You have to understand both of them are connected, and both are a prerequisite for the definition of terrorist activity. Now, there's this very important caveat that is also included in the definition, which says that for the purposes of the definition of terrorist activity, any act which is committed in pursuance of any advocacy, protest, dissent, or industrial action, and which does not intend the harm contemplated in paragraph 1 to 5 of that definition shall not be regarded as a terrorist activity. And I think this is at the core of what we've been discussing today, issues around religious freedom, the rights of self-determination within the country. Because what this clearly states in this definition and this caveat here is that protest, anything that is done legally without the use or threat of violence, cannot be considered a terrorist activity. And so I'd really like to tell Foresight and the Cape Independence Party that I think this legislation and this definition is specifically clear enough that it would be very, very difficult, if not impossible, to have abuses under this act, because so much effort has been put into this to try to clearly set the boundaries of a terrorist activity. Let me turn now to this issue around prohibiting the publication of unlawful terrorism-related content. We know that this is something that has happened in South Africa, and we know that South Africans have tried to encourage other South Africans to join these groups and to commit offenses in South Africa. And this is an opportunity for us to intervene prior to radicalization and prior to the commission of an act. This is what we would call a precursor offense. So if we are able to prevent people from accessing this content, we can prevent them from being radicalized, or at least help to prevent them from being radicalized, which would ultimately prevent them from carrying out terrorist activities. And again, there are very important caveats in the proposed clause 3 of the original bill, which limits the boundaries of how to apply this. It says unlawful terrorism-related content means content which is intended to indirectly or directly or indirectly encourage or otherwise induce the commission, preparation, or instigation of any offense under this act. Again, we have two parts here. We have A, the encouragement, and B, committing a specific offense. Purely encouraging people to protest or to dissent would not be considered a terrorist activity, nor would it be considered as unlawful terrorism-related content. And I'm reminded now of an earlier question one of the honorable members posed around Cosatu protesting Eswatini. And what we've seen in the previous definition is that we say that protesting is okay. So Cosatu could very rightfully protest Eswatini, the Eswatini government and the king, and try to get him to change policies. But if Cosatu were to engage in a violent act or a conventional offense to try to force the government in Eswatini to conduct themselves in a certain way or to change their mind, this would be considered a terrorist activity. And it's very similar to what we have here. If we have Cosatu encouraging people to commit a specific offense, then this would be labeled as unlawful terrorism-related content. A very important point that we often miss in this discussion around free speech and what exactly this is limiting is around what offenses we are saying should not be allowed. Nobody has any issues with these specific offenses. Most of these relate to international obligations that South Africa has due to treaties that we have signed or agencies that we have signed up to. For instance, in the case of FATF and the financing of listed terrorist organizations, this is an international organization, agency that we have voluntarily acceded to and signed up to be a part of. Similarly, when it comes to the majority of these convention offenses, this is something under international law, which we have agreed to as South Africa. And we all agree that these offenses are incorrect. And what I say today to you is that we should similarly, acknowledging that these offenses are incorrect, we should similarly criminalize people, encouraging people to engage in these very egregious offenses, because we know that this poses a risk to the security of South Africa, and that we've seen literal cases where individuals have been encouraged to engage in this type of activity and have threatened the lives and the economy of South Africa. And if we turn to Article 16 of the Constitution on the freedom of expression, it is very clear that there are certain limitations to the freedom of expression, which is precisely what I'm arguing for today, and which we see in the definition of terrorist activity and the above definition on unlawful terrorism-related content. Article 16 of the Constitution very clearly states that the right to freedom of expression in subsection 1 does not extend to propaganda for war or the incitement of imminent violence, which is precisely what people are doing through posting and sharing online content that is intended to radicalize our young people, to join extremist groups, and to engage in violent terrorist activities. There's also an important caveat that has been included in the proposed definition or the proposed clause around the prohibition of publication of terrorism-related content. And this is around the right to a legitimate defense. And we've mentioned here, it is okay, it would not be considered a terrorist activity or an offense if a person had these documents in their possession, if they didn't know of it, but equally if they were carrying out this work as a journalist or as academic research. Now, this is very helpful for, again, helping define the boundaries of how to apply this law. But let me also just point out that these two legitimate offenses raised here are not all encompassing. If you have to understand South African criminal law, you have to prove without reasonable doubt that there is unlawful intent in the activity that a person has perpetrated. So if I could refer to some of the issues we've discussed today around self-determination, here we clearly have boundaries around what is considered a terrorist activity. And an issue like self-determination would not fall within those boundaries because it is not necessarily advocating for a violent offense, and so would not be considered as a terrorist activity or be seen as an offense under this piece of legislation. The reality that we see today, and that I've tried to convey to the committee, is that there are young South Africans that are being radicalized in this country, that have become susceptible to terrorist-related content, that are being told all sorts of stories that get them involved with these groups. And once they get involved, they fall deeper and deeper and are more difficult to turn around. And as we've seen in the case of the Tulsi twins, allegedly have thoughts of going to the extremes of committing a violent act in South Africa. And the inclusion of this clause 3, which I think is very important and something that we see internationally in many countries, and which is something that CTED, the Counterterrorism Executive Directorate, advocated for as well, is that this is an opportunity for us to disrupt the chain that leads from radicalization to the perpetration of a terrorist act. I would argue that the inclusion of this bill, or this particular clause in the bill, has the potential to save lives. And there are very appropriate boundaries around when this legislation can be applied to prevent abuses. We have numerous safeguards that have been alluded to, including around the Independent Prosecution Authority. But we also forget that South Africa has a strong legal system and strong independent courts. We think merely in terms of the government or the national prosecutor committing in and of themselves abuses of this particular legislation. But ultimately, it is the highest courts of this land that have to decide whether particular acts constitute terrorist acts. And this is something that I believe that our constitution and our constitutional court is capable of understanding, and that has in the past protected South Africa from these types of acts. And finally, I think that the definition and boundaries of the legislation are extensively defined. A significant amount of work has gone into the definition of a terrorist activity and the convention offenses here. And there are very clear boundaries and prerequisites for something to be considered a terrorist offense. And there are very clear boundaries to protect free speech and legitimate dissent. And this is something that we already see in the legislation. And a lot of what we've heard today, I think, stems from a misunderstanding of how to interpret and read this very complex piece of legislation. That's the end of my presentation. Thank you so much to the committee for this opportunity, and I welcome any questions. Similarly, if you'd like to reach out to me, I would be very happy to speak to anyone. Thank you.
Thank you very much, Dr. Schoeman, for that presentation. Let me hand over then to the department but I see Honorable Dango, your hand is up. I'm not sure when it was raised, but
yeah, I'd like to ask Mr. Schoeman.
Okay, Honorable Dango, can I ask you to hang on to that question and let the department respond, and then we'll get to your question, Honorable Dango.
Thank you.
Okay, let me hand over to the department.
Thank you, Chairperson. Yes, before I start, I would just like to thank Dr. Schoeman for providing further clarity on the definition of terrorist activity. We really appreciate that. Going on to slide 14, we have summarized in very short terms the comments made by Dr. Schoeman, which is a proposal that the clause prohibiting the publication of unlawful terrorist content should be returned to the bill. The clause related to the prohibition of any publications with terrorist-related content in the original amendment bill sought to create an offence related to the publishing, distribution, or circulation of content to encourage or induce the commission of any offence under the Principal Act. During the public participation process, when the bill served before the Portfolio Committee on Police, the department carefully considered all submissions and cautioned us about the constitutionality of the clause and possible infringement on the right of freedom of expression, and agreed to propose to the Portfolio Committee on Police the deletion of this clause. Certainly, it is important to ensure that the publications with terrorism-related content that encourages the commission of an offence of this act is not left out. And after consideration, we were of the opinion that prosecutions of publications with terrorist-related content can be prosecuted under Section 14 of the Principal Act. Section 14 reads that any person who threatens, attempts, conspires with another person, or aids, abets, induces, incites, instigates, or instructs, or commands, counsels, or procures another person to commit an offense under this act is guilty of an offense. So that is actually the clause that we referred to when we said that publications with terrorist-related content can still be catered for in terms of the current Principal Act. And yeah, that was our recommendation, Chairperson. I'll just leave it there for now. Thank you.
Thank you, Dr. Skuman. You could come in before members ask any questions.
Thank you so much, Honorable Chair. Advocate Kretziger, thank you so much for that. I was similarly looking at section 14 that you've just mentioned, and I think it would be, and I think you're right, it could be possible to prosecute people under that specific section for publishing terrorism-related content. My specific intervention here and concern relates to some of the issues around specificity. I think when it comes to applying this law and what we've seen in the case of the Henry Oka trial, the judges have had some issues with interpreting this legislation precisely because it is so technical and difficult to interpret some of these because it is a very complex issue. And my proposal around returning clause 3 to the bill is so that we can have some greater clarity on the boundaries of what offenses related to publishing terrorist-related content would constitute. I think this would help judges in their interpretation and application of this law, but I think it would also equally make it clearer to the public what is and is not permissible. So that would be my response. Thank you.
Thank you very much. Let me then hand over to Honorable Dango. You had a question you wanted to raise, and any other honorable member?
Yes, thank you. My question is to Mr. Skuman. One is, how does he consider, for example, advocating for the freedom of the Sahrawi people in the case with Morocco? If Moroccan state brings a case against or civil action against such activists. Two is, in the case of Israel, where soldiers from South Africa go and in an undefined way help to dispossess, oppress other people, are those soldiers subject to being prosecuted in terms of this act? And three is, on the flip side, those fighting for what they consider the liberation of Palestine, how would they be considered? Would that be considered as terrorism against the state that is doing illegal things? Thank you.
Thank you very much, Honorable Dango. I think Mr. Miller wanted to also, I would imagine, make an input, Mr. Miller. Mr. Miller?
Yes. Yes. I just wanted to Honorable, sorry, the previous speaker there.
It's Dr. Skuman.
Yeah. Okay, so sorry, we had load shedding here, so I missed the last sort of 15 minutes there, but I'm back. I wanted to just make a comment with regards to Dr. Skuman's initial presentation with regards to the subsection 4 relating to self-determination. And once again, I agree with the vast majority of what he had to say. The only issue that we have is that everything, all the concerns that he raised
we believe needs to be tied back to a very important definition, which I think everyone accepts. Terrorism has to have an element of violence to it, especially with regards to self-determination. So political pursuits for self-determination certainly should not be classified under anything relating to terrorism. So if one could remove references to violent acts in an armed struggle, I believe that would satisfy some of those concerns. And again, to reiterate what Advocate Kritzinger had said earlier, we're referring to potentially life in prison and fines of 100 million rand and 15 to 30 years in prison are some of these potential sentences. So it's very important that the definitions are clear. And even though Advocate Kritzinger did give a reassuring response, which I'm appreciative of, unfortunately, I don't think that Advocate Kritzinger's response is in line with what we're seeing in these amendments, whereas Advocate Ellerbeck mentioned that simply a terrorist act could be classified as any act attempting to overthrow the government, and that term overthrow is very broad and there aren't any definitions to it, and so these remain serious concerns. So that's the commentary I wanted to just add.
Okay, no, thank you, Mr. Miller. I think when your hand was up, the hands of other honorable members were not up at the time. They somehow raised it after I had recognized you, but let me rather allow honorable members. We note, and I'm sure Dr. Skuman has also noted what you said, and Advocate Kritzinger. Let me just allow honorable members then to engage with Dr. Skuman and the department's response for questions of clarity. Let me go Honorable Dodovu, and then it will be Honorable Matsama.
Yes, Honorable Chair, thank you very much. A quick one. Firstly, I think the presentation was very good and informative, and I'm happy that the institutions that are doing such a great work in terms of research on this area, which is extremely important. Now, just a quick one. Dr. Skuman stated that he, together with a certain Kachalia, wrote an article and published it where they assess the violent extremism in South Africa. Where can I access that document, if it is possible? I will appreciate that. That's the only point, Honorable Chair. Thanks.
No, it's fine. Honorable Matsama.
Thank you, Chairperson. Chairperson, I was just want to ask Advocate, what advices can he give to us, South Africa as a country, about the issue of Israel, apartheid Israel regime that is terrorizing the Palestinian people? What can he advise us? Because we saw on the TV, we saw on the media, social media, where they attack a school with children inside the school. What advices can he give it to us? I thank you, Chair.
Okay. All right. I think, thank you very much, Honorable Matsama. And I think Dr. Miller has put the link on the chat group for Honorable Dodovu. I see also the hand of Ms. Ellerbeck. I would have preferred that we had this engagement, but because Mr. Miller had to raise his concern, Ms. Ellerbeck, perhaps you can come through now as well. If you have a concern, but I see you lowered your hand again. Okay. Yeah.
I lowered it. You recognized it. Honorable Person, thank you. I appreciate it. I just wanted to make a comment, if that is allowed, on something that Dr. Skuman Will you allow
Salva, your
it,
signal. Yeah, you're not very clear. I don't know if it's your signal.
Yes, explosion.
We can't hear what she's saying
in his presentation.
Yeah, Ms. Alabak, you're not clear at all.
Okay.
Can I propose that you put it in the chat group? If we cannot hear you. Okay, all right. Let me then hand over to Dr. Schoeman. Thereafter, we'll go back to the department. Dr. Schoeman.
Thank you so much, Chair. I think I can answer the three questions from Honorable Dango, Mr. Miller, and Honorable Matsamai together, because I think they're very related issues around this question of national self-determination. And this is, of course, always such a difficult issue to deal with when we look at definitions of terrorist activity. And there's always the famous saying of one man's terrorist is another man's freedom fighter. But this thinking has evolved quite significantly post 9/11, that we have a lot of international conventions and guidance from the UN Security Council, as well as the General Assembly, around how to understand this issue of terrorist acts. And increasingly, the understanding is very in line with what we've discussed today around the definition of terrorist activities, that we need to consider two things. First is the violent and often indiscriminate act. And second is the issue of trying to coerce somebody. We can think of individuals such as Pablo Escobar that engaged in narco-terrorism. There was no ideological motive behind this. And increasingly, when we talk about terrorism in the international sphere, we focus more on the perpetration of the act rather than the ideology or the reasoning behind it. And in fact, there is a clause in POCTATARA that specifically says that ideology, political motive, is not a legitimate defense for carrying out these acts. And that is precisely because, as an international community, we've determined that certain acts on civilians are so egregious that there is no just defense. I completely sympathize with Honorable Dango and Honorable Matsamai's concerns for the Sahrawi Arab Republic and Palestine. I think these are terrible issues, and I think we can completely support their independence. But there is a difference between supporting their goals and their ideology versus supporting the perpetration of specific terrorist acts which are criminalized under international conventions to which South Africa is a party and to which the international community considers problematic. And these are things around nuclear terrorism, the use of chemical weapons, issues such as that, that we mutually agree that certain things are not allowed in a struggle for self-determination. And I think this is what we need to keep in mind, that we need to distinguish between the act and realize that terrorist activities are not a legitimate means of struggle versus the motive of specific organizations and the goals that they're trying to achieve. Because in many cases they are noble and we can support those noble goals, but we cannot support them perpetrating terrorist acts. And I think likewise on Honorable Matsamai's comments on Israel and some of the things that they have done there, we have international laws around the Geneva Convention on Just Warfare and under which conditions certain acts are illegitimate. And I think this is a somewhat different question to terrorist activity perpetrated by non-state actors. And potentially there is a case for countries that are perpetrating state-sponsored terrorist acts under international criminal law to stand trial for some of the activities that they have perpetrated. But that, I guess, is not for us to decide here today. I hope that I've sufficiently answered your questions. Thank you so much.
Okay, no, thank you very much, Dr. Skuman. I think before I even release you, there's a comment by Ms. Alabak in the chat group, where she indicates that you mentioned subsection 3 of the definition of the terrorist activity in the Principal Act as being added protection. However, if you look at the bill, vague and in brackets undefined or no criteria, phrase such as is calculated to overthrow the government, it will be added in as a subsection Roman numeral 2A. That is, it will fall within the sections mentioned by subsection 3, and thus if you have advocacy that is deemed by the state as being to overthrow the government, then subsection 3 offers you no protection at all. Again, the vague phrases are dangerous and need to be fixed. Okay. If you have a comment on that, and then we'll move on to the department's response. Dr. Skuman?
Thank you, Honorable Chair. This is quite difficult for me to just answer in the moment. I'd have to specifically look at this and read it all together. This might be something that the Civilian Secretariat might be able to help with. But in the moment, I wouldn't want to pose an opinion on this.
That's fine. Thank you very much, Dr. Skuman. Over to Advocate Kritzinger.
Chairperson, we will also have to look at it before we respond, please. Thank you.
Okay. Okay, thank you very much. I think we've exhausted the briefings for today. Maybe Minister DM from your side, do you have any final comments you'd like to make?
We can't hear you, Chair.
DM, I said if you had any final comment to make, we actually done with our hearings for today.
Oh, okay. No, thanks very much, Chairperson and members of the NCOP and those who made submissions today. It was quite insightful and quite highly appreciated. And I think the Secretariat and the team, we gain and we become better as we interact with yourself, Chair. We look forward to our continuous engagement. We will be available for the next session to interact with yourself so that we give you the necessary information for you to handle your issues. But thanks very much, Chairperson.
Okay, no, thank you very much, DM. Let me also take this opportunity to thank the organizations, FOSA, through Ms. Alabak, the Cape Independent Party, through Mr. Miller, and Stern, through Dr. Skuman, for your submissions and for the time that you've taken to address the committee on the submissions that you made on the bill. Let me also thank the department and the legal team from the Civilian Secretariat as well for this engagement. As a committee, this engagement, I think, has certainly given us as members a clear sense of the concerns raised by the organizations in respect of the bill. And I should also indicate that the oral submissions will continue tomorrow. We are expecting 2 new organizations as well to make those submissions. The committee itself will also deliberate further on a later date on the submissions made and on the departmental responses on the bill. And this would be probably later this week, and as set out in our program on Mondays. Yeah, so with that said, let me thank you very much to the 3 organizations and to the minister, the deputy minister and the team. I think, Dr. Skuman, there's some comments for you as well on the chat group. You could look at that. But as well as the issue that was raised, if you have an input to make, you could probably provide us that in writing as well. Thank you very much, everybody. This meeting is closed for now.
Thank you, Chair.